he's in Judge Board's about to run anything. He's been sick. And he wants a waiver, so one of his colleagues gonna help on his behalf? Who wants a waiver? That's for O'Neill. Oh, okay, yeah. So we don't know what's going on with Johnson. Johnson? On the record in the matter of the state of Michigan versus Christopher Johnson, 25-01413, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill, on behalf of the people, I'm going to make a motion to practice under Michigan Court Rule 8.120. I did have a supervisor here a moment ago, Matt Nagel. I believe he just stepped out for a second.
Ms. Austin, can I get your appearance for this limited purpose, please?
Mr. Johnson, did you say, Your Honor?
That's correct. I think Mr. Lee represents him.
Okay. And good morning, Your Honor. Jared Austin, appearing on behalf of Mr. Johnson, filling in for counsel record. Mr.
Looks like it got moved around. Looks like at one point it was Mr. Goodrich. I see an email that it went to Mr. Lee at PPC, but I don't know what we're doing today. It says Mr. Lee will cover for Mr. Goodrich. Is that what? Yeah, because he's in
Mr.
trial.
Goodrich is in trial, so I'm assuming that's what that means.
So Mr. Lee's supposed to be covering, but Mr. Lee is not here and has not advised as to what we're going to do for Mr. Johnson. And I don't know if Mr. Johnson spoke with his attorney or not. Mr. Johnson, have you spoken with your attorney?
No, ma'am.
There's notes in the file from July 9th from Mr. Goodrich. It would seem to indicate that he spoke with Mr. Johnson.
Okay. Let me repeat the question because sometimes they think, did he speak today? Have you ever spoken to your attorney, Mr. Johnson?
Yes. I haven't spoken to him today, though.
Okay, very good. Okay, your attorney today, I believe, is at trial. So I just wanted to make sure you have spoken to him at some point since the time of your arraignment. It looks like you did. You're currently scheduled for preliminary examination on the 24th of July. That's next week in this court at 9:30. I'm going to assume we're going to continue to the exam at this time, okay? But if well, your attorney will advise us, okay?
Yes.
Okay. Do you have any questions for the court at this time?
No, ma'am.
Okay. Any additional matters for the record?
The people would just like to put on the record that there is no offer on this at this time. I do not anticipate that there will be one at the district court level, but negotiations would continue in circuit court.
Very good. Thank you for filling in.
Nothing additional, Your Honor. Thank you.
Thank you. You're all set, Mr. Johnson.
Thank you.
Did we see Mr. Pickling? He's downstairs talking. Okay. Oh, O'Neill's here in person.
Yeah.
On the record in the matter of the state of Michigan versus Abigail Brown, 25-01213, appearance, please.
Peter Morris here.
Morning, Your Honor.
I'm sorry.
That's okay. I hesitated a bit. Haley Fortuna Gill on behalf of the people, Your Honor.
Peter Morris here on behalf of the defendant who is present, of course, via Zoom video conferencing.
Okay, this matter was scheduled for a probable cause conference for unlawful driving away, 2 counts. Let's see, how are we proceeding? Are we going to be running an exam next week?
If I may, Your Honor, I do not foresee that happening. I definitely, and I've had good communication with my client. In addition, Ms. Fortuna Gill and I have exchanged emails. I do want to clarify a few things. So perhaps, if possible, if I could meet in a breakout room with either Ms. Fortuna Gill or Mr. Nagel, that would be great.
It looks like we sent you a chat earlier to see if you needed to speak with anyone. Now we're on the record, so she can't step away because I have a courtroom full of people.
Oh, I understand. I'm so sorry. I guess I didn't see anything. I just saw something about a breakout room being open, but I didn't see I was assigned to one.
Yeah, Ms. Nash sent you a chat to see if you needed to speak with the prosecutor.
I can give him a call this afternoon, Your Honor.
Okay. Well, it sounds like Ms. Fortuna Gill will contact you this afternoon.
That sounds great, Your Honor. And like I said, just a few practicalities because my client is now a California resident and lives in San Diego. In fact, she's zooming in this morning from San Diego. And I just had questions about circuit court, mental health court and circuit court. That's all. And I just wanted to make sure it was a practical fit because I think that's the way it's going to be resolved.
Okay, at this time, I'm going to note that it's going to continue to examine until someone confirms otherwise. And then Ms. Fortuna Gill will contact you later, and you all can send an update via email about whether or not this will run an exam.
Very well. Thank you, Your Honor.
Thank you. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
No, Your Honor. Thank you.
Thank you. Okay, on the record in the matter of the State of Michigan versus Britney Chimki. This is 25-01475, appearance brief.
Haley Fortuna Gill on behalf of the people.
Thank you, Your Honor, and good morning. Jared Austin, appearing on behalf of Ms. Chimki, who is approaching counsel today.
I knew when I said the name, I didn't take this plea because I've never said the name before. Okay, so this looked like it was a plea taken before Judge Buchanan on May 23rd. During the time of the probable cause conference, she pled guilty to count 2 of domestic violence. Count 1 was dismissed. And I do have a pre-sentence report. It was prepared on June 6th. Did you get a copy of that, counsel?
Yes, Your Honor, I have a copy of that. I provided a copy to Ms. Chimki, who has reviewed it as well.
Do we need to make corrections, updates, or deletions?
No, Your Honor, I believe it would be accurate as well as complete.
We can make allocution.
Thank you, Your Honor. Ultimately, I do find the recommendations to be appropriate, and I would ask the court to adopt them. Ms. Chmielewski's prior criminal history is rather limited. From what I can see in an iChat, the pre-sentence report certainly doesn't contradict this. The only prior convictions that I'm aware of is 7 years ago. She had a conviction for drunk driving in MIP, I believe. The report notes details about her mental health history and some mental health episodes she was going through at the time this occurred, which I think likely played a huge role in this, resulting in Ms. Chmielewski acting out in a way that she normally would not. Appears that also alcohol was involved that she was using at that time as a means of self-medicating, as she stated. Those two can often go hand in hand, but she has admitted to what she did. She acknowledges that it's wrong and wants to do better. She's a mother of 3 children. She's not had any pretrial release violations, no violations alleged, no contact orders that I'm aware of. All this case has been pending. I believe that compliance will continue on a term of probation. I would ask the court to sentence her accordingly and to grant her the special status to allow her the opportunity to earn a non-public record for this offense. Thank you.
Does your client want to make a statement today?
She does not. Thank you.
I reviewed the pre-sentence report and the recommendation, as well as your prior criminal history, which your attorney accurately addressed. Limited prior criminal history. And it seems the trend would warrant treatment for substance abuse, and that might address your engagement and interaction with the criminal justice system. And so I'm going to adopt the recommendation. You will be sentenced to 93 days in jail, credit for 1.
Does that start today?
I wasn't finished. I just paused. I said I was going to adopt the recommendation, so that means you are going to do probation. But the 93 days is being held over your head. Okay? I'll suspend the balance, and I was pausing because I was writing it, of 92 days upon successful completion of 10 months probation. While on probation, we made the space even smaller to put stuff in here. 10-month probation. While on probation, you have the following conditions. I'm going to continue the no contact order with David Chimki. You're not to engage in any type of assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or a weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. I did note that you have a valid medical marijuana card attached to the file, so that allowing medical marijuana will be granted. You will be subject, however, to random preliminary drug testing and urinalysis testing. You're responsible for the cost of that, okay?
Yep.
And you're also not to be at any nightclubs or bars while you're on probation. I will grant status under 769.4A, which if you're successful on probation, will make this a conviction non-public, okay?
Okay.
You are employed, is that correct?
No, I stay at home.
You stay at home with your children, is that what's going on? How old are your children?
I have a 1-year-old, a 2-year-old, and a 4-year-old.
You gotta stay at home.
Yes.
Okay, we will not order employment at this time. We ordered to participate in early alcohol education. And all other treatment as recommended. Okay? You have any questions so far? Fines and costs. There's a $75 crime victim rights that must be assessed. Per statute, and a $50 state minimum cost that also must be assessed. Let me see if there's OWI cost recovery because it's not listed on here. Okay, let's see here. I'll waive discretionary fines and costs. There is a $30 per month oversight fee that you will be responsible for while on probation. So 10 months of probation at $30 per month is $300, okay?
Okay.
You will have the opportunity to make monthly payments. Your total fines and costs will amount to $425. Let's see, lastly, there's an advice of rights as to you're being placed on probation. I'll give you this for your personal information, but essentially you're not eligible to request early discharge because you are on probation for domestic violence, okay?
Okay.
You'll check in with our probation department before you leave. We'll get you this, you can pass me that copy. Do you have any questions at this time? Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor.
Thank you. You're all set. Can you represent Mr. King as well?
I do.
Okay, on the record in the matter of the state of Michigan versus Merl J. King Jr., 25-00542, appearance, please.
Haley Fortuna Gill on behalf of the people.
And thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. King. He appears with us remotely from the Ingham County Jail.
Okay, Mr. King has a probable cause conference today on controlled substance possession method ecstasy matter is scheduled for a preliminary examination next week on July 24th at 10 a.m. Are we continuing or are we resolving it today?
Well, Your Honor, a misdemeanor offer was extended that Mr. King wishes to avail himself of, so we could do the plea today.
The offer is use with consent to 7411, if eligible.
Okay, and Mr. King, you want to accept the offer and plead guilty to use of a controlled substance with the prosecution consenting to your being sentenced under 7411 if you are eligible?
Yes.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Mr. King, you have certain rights that you need to understand and that you would need to give up if you would like to accept this offer and plead guilty. First is your right to the presumption that you are innocent. So you have the right to maintain your innocence until proven guilty, and the prosecution would have to prove your guilt by proceeding to trial and proving each element of the charge that's being brought against you beyond a reasonable doubt. You understand that, right?
Yeah.
You have the right to maintain your silence and not have silence be used against you, or you can waive silence and testify at your trial. You have the right to subpoena witnesses that will testify on your behalf, the right to see, hear, or question in court any witness that the prosecution calls to testify against you. Do you have any questions about any of those rights?
No.
And are you willing to give each of those rights up today in order to plead guilty to the amended charge?
Yes, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand that by pleading guilty, it could result in a conviction that you may need to report to a current or future employer.
Yes.
By pleading guilty, it also could result in a conviction that may have impact on travel or immigration status.
Yes.
You understand that? Okay. As to the amended charge of use of a controlled substance, how do you plead?
Guilty.
And is that because you believe you're guilty?
Yes.
Factual basis, counsel.
Yes, Your Honor. Thank you. Before I begin, I just wanted to be candid about one thing. I understand that people are not objecting to 7411 status. Mr. King is before this court pending sentencing for the same type of charge, so I don't think he's going to be eligible.
Thank you.
But Mr. King, I want to take you back to November the 26th of last year, 2024. Were you at or near the area of South Hosmer Street and Kalamazoo in Lansing?
Yes.
Is that here in Ingham County?
Yes.
At that date, time, and location, did you have a controlled substance in your possession on your person, more specifically methamphetamine?
Yes.
That's because you had placed it there at some earlier time, is that correct?
Yes.
And that was intended for your own personal use?
Yes, sir.
All right. Satisfactory, Your Honor?
Any questions from the prosecution?
No questions, Your Honor.
I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Matter is scheduled for sentencing September 12th at 9 o'clock in the morning. Is he being held on this or something else?
Well, Your Honor, Mr. King had earlier this year pled to use of meth. In the interim period between that and sentencing, he failed to appear for his PSI and ultimately sentencing. And so he got picked up on that warrant And as well as in the interim, this charge had been issued. So I think he likely has no bond on the older file. It's currently pending sentencing before Your Honor on August 7th. Since it's the same exact offense, would the court be able to do the sentencing for this on the same day?
August 7th is fine. I don't know. We have to make sure they're doing a PSI. If he never got a PSI, I don't know. I'm not sure if he got a PSI. Was the August 7th one? Yeah. You failed to appear for the sentencing August 7th?
No, it's
Or no.
currently set for August 7th.
When was it previously set?
He pled in February. The sentencing was set for April. He never
Okay.
appeared for the PSI or the sentencing.
Oh, so we don't have a PSI.
So
we-
now that he's been
we need
remanded, I
both
would,
of them to be set for the 12th of September then,
okay.
because we need to get a PSI. So we'll have the other matter set before me the same date and time. And then you said he has a sentencing before in the circuit court as well?
No, Your Honor, just here.
Oh, okay, got it.
When they arraigned him on the bench warrant for failure to appear, they set his sentencing on the original file before Your Honor for August 7th.
Interesting.
So I was hopeful they would have the PSI done by then, but never.
And he was arraigned on the bench warrant July 7th, maybe?
That sounds about right, because I think he was picked up around the 4th of July holiday.
It doesn't say.
Yeah, but I wonder if they met or planning to meet with him. We got at least a month. Right. Good morning, this is Judge Simmons. How are you? I just have a question. I know it's something that's not out. I am trying to schedule a sentencing for Merl King. And my understanding is he has another sentencing committee performing that's scheduled August 7th. But it looks like he was arraigned on a bench warrant on that other file on July 7th. And he's in custody now. So I'm wondering if someone's met with him for the PSI. The PSI is expected to be prepared for that August 7th sentencing. Yes, and you are. Correct, that's the one that I think he had a bench warrant for the PSI and sentencing. So he was picked up, and arraigned on that bench warrant. And then they set that sentencing for August 7th. I just took another plea, same or similar charge. And I would set this for the same sentencing date if he's already on the PSI. If not, no worries, I'll just reset both of them to September 12th. All right, thank you. All right, thanks. think they got a referral
Oh,
on the other one. Okay, so we'll set both of these for sentencing on September 12th,
What was the time on that date?
9 a.m. Okay, any additional matters for the record?
Nothing on behalf of the people, Your Honor.
I have nothing additional back, Mr. King, Your Honor. Thank you.
Okay, you're all set, Mr. King. Mr. King, you're free to go. Mr. Quickly is here for O'Neill. We can have O'Neill brought up. On the record in the matter of the state of Michigan versus Shawn Williams, 25-01951, appearance case.
Haley Fortuna Gill on behalf of the people.
Your Honor, when I hear you want you from Mr. Williams, who is at the council table.
I like the jacket, very nice.
Thank you.
Today's the date scheduled for a probable cause conference on a criminal sex crime second degree. It's scheduled for exam next week on July 24th at 10 a.m. Are we continuing?
We are, Your Honor.
Any matters we should address on the record today?
Not on behalf of the people, Your Honor.
I think on more discovery, but I can talk to the prosecutor about that.
Additional discoveries being sought? Okay, but nothing that needs to be placed on the record. Okay, well then we'll see you next week at 10 o'clock in the morning.
Thank you, Your Honor.
Thank you.
Other key file, will you put it down here,
Which one?
the key file? I just want to put that second time referral for the other
I
one
don't,
there.
oh, I don't, did he bring me the file?
It's downstairs, but just to
Oh.
put it with the other one.
Oh, no, it's right here. Mr. Etheridge, I think it's on. Mr. Lee, how are you? My understanding is you were supposed to be representing someone at 8:30 today.
Yes, that is true. I'm sorry, I got held up in a preliminary exam scheduled at 8 a.m. down there.
Did you stop by here to leave a note as to what you all expected to do?
No, I apologize.
Don't worry, Mr. Austin fell on the sword for you. He stepped in and took care of it.
Appreciate it.
You owe him lunch.
I agree. All right, it's done.
Thank you. saw Mr. Etheridge, but I don't see him anymore. Let's see.
Have we seen Mr. Mulawad, Wes Mulawad, the attorney for Mr. Tyson, appear in Zoom?
I'm here. I'm here.
Oh,
I was gonna say Mr. Wu. You need to speak with him? Is that?
he's the attorney on the PCC for Tyson this morning. If I could, so if he's on Zoom, I'll go into a breakout room in another room, like talk to him for a minute.
I'm gonna put you in a private meeting room with the prosecutor on this file, okay? Did you want your client in there or just the two of you off? for now?
Just the two of us.
Okay, sounds good.
Thank you very much.
Thank you.
And you do have the Zoom number.
Is Shawn Williams here, or I just did that one? Is that correct? I did.
Yeah.
Okay, I'm just waiting for Mr. Etheridge for Mr. Smith. On the record in the matter of the state of Michigan versus David Wayne Coker Jr., 25-01444, appearance, please.
Morning, Your Honor. Kelly Megacy, Assistant Attorney General on behalf of the people.
Good morning, Your Honor. Josh Blanchard on behalf of Mr. Coker, who is also via Zoom.
Okay, today was the date that we rescheduled a probable cause conference. It looks like we are looking to set an exam or next action. Is that correct?
That's correct, Judge.
Oh. And how much time do you believe that the exam will take?
I would expect to have 4 witnesses. I'm not, so I think it would be best to schedule this. Mr. Blanchard, do you agree for all day?
I would think if you have 4 witnesses on a case like this, we could eat up an entire day.
Sounds good.
We had Judge reached out to your clerk about potential dates, and due to schedules, council's schedule and my schedule, we were with the court's permission looking at October 10th.
Yes. Works for me.
Thank you,
At
Judge.
9:30?
Yes.
October 10th, 9:30 in person at the court. Any additional matters for today's record?
No, Judge.
Thanks, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
No problem. Let's see, that's done. Bring up Neil. And then Mrs. Narrows, are we running Love?
We are not, Your Honor. It will be a waiver.
I saw Miss Donnelly, but I don't remember. Let's see, they're talking about now. Oh, let's see, what's going on with Morrissey? Is that expected to run?
It's anticipated to be okay, Your Honor.
On the record in the matter of the state of Michigan versus Benjamin Thiessen, 25-01973. Counsel, appearance, please.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Your Honor, good morning. Elias Muad appearing on behalf of Benjamin Tyson.
Okay, today is the date scheduled for a probable cause conference. I have a 10 count criminal sex crime complaint here that's scheduled for exam July 24th at 10:30. Are we continuing to exam at this time?
Your Honor, after speaking with defense counsel, I believe that they need an adjournment due to there being 143 pieces of digital evidence, evidence.com, that there seems to have just been an issue with the download link. I will let Mr. Muad make the adjournment request.
Thank you very much. Yes, Your Honor. I think all I was asking for is a waiver of the 21-day rule and a request to just adjourn to PCC. I don't think this case is going to go to exam based upon some issues that I'm going to talk to my client about, but I just want to make sure he sees this other evidence, and that's what I'd like to do if the court will allow it.
I'll treat next week as a probable cause conference.
That works. And then do we want to figure out a new date now, or do we want to figure out a new date next week?
Well, it sounds like he doesn't believe he's running an exam.
Correct.
So that means
Honestly,
he must be waiving.
We're going to eventually waive. I just want to make sure that there's no issues, Judge, with my client saying he didn't see all the evidence. I know that if he goes to exam, there's also a issue of more charges, and I will explain that to my client.
Okay, so I can treat next week as a probable cause conference. I can schedule another exam date at that time if necessary, once okay, or if the timeline needs to be waived.
That works with the people.
That's fine, Judge. I appreciate you guys. Yes, thank you.
No problem. Any additional matters for today's record?
No, Your Honor.
No, Your Honor.
Thank you. You're all set.
Thank you. Ben, I'll give you a call.
Right.
I'll put it back in back. I appreciate it.
I've seen my wife check my office. That was her bag. Connolly, have you seen Lance Richmond?
Your Honor, I was sorry, I was just didn't finish the preliminary exam. Yes, I've had phone calls with him this morning, or I had messages from him. Have you appeared yet? Because I tried to.
No, that's why I was asking you, have you seen him?
No, I haven't. I'll go put him on the phone. Because I gave him new information.
Your Honor, it does look like we have everybody for Love as well as O'Neill. Those are both going to be waivers.
Record said Love is in custody.
Yes.
So we don't have
Do
everybody. That's why I was waiting for them to bring.
Got it.
O'Neill so that we can bring Love.
Yep. Got it.
There must be some delay down there. Let me see Miss Schroeder today. She must be in the board.
I've emailed with her this morning, but I don't think she said where she was.
I know she has, yeah, some award and some report.
See if I can. Record in the matter of the state of Michigan versus Erica O'Neill, 24-02381, appearance, please.
Haley Fortuna Gill on behalf of the people.
I'm Bobby Fickle on behalf of the committee.
Okay, today was the date that we reset probable cause conferences for criminal sex crime, 4th degree. How are we proceeding?
Your Honor, we are waiving the preliminary exam and we found that on the circuit court.
The people would also waive the preliminary examination, Your Honor.
Mrs. O'Neill or Miss O'Neill? Can you hear me?
Yes.
Okay. Do you understand that you have the right to have a preliminary examination on this felony that you're being charged with? You understand the purpose of that exam? So you have the right to have the prosecutor put forth evidence here at the district court that would first establish that there's sufficient probable cause that the felony alleged was committed, and then sufficient probable cause to charge you as the person who committed the felony. You understand that? Do you wish to waive that exam? Anyone threatening you to do that? Any promises if you waive your exam? You understand the waiver is unconditional, correct? You can't get to circuit court, decide you don't like your offer or that there is no offer, and then request your exam. You recognize that? Thank you. So now I find your matter to be freely and voluntarily waived. The matter will be found over to the circuit court. The bind over date is July 30th. That's the date the circuit court will receive the file from the district court, not a date that you need to appear in court, okay?
Thank you, Your Honor.
No problem. Your next court date, Ms. O'Neill, will be a pretrial in the circuit court. Let's see, it looks like your bond in this matter was set at 10,000 personal recognizance. Let's make sure that didn't change. Is that still what you see in the system? No, I see 5,000, 10%. 5,000, 10%. That will continue. Any additional matters for the record?
Can I address the bond, Your Honor?
Absolutely.
Ms. O'Neill found out about the warrant, but she did not show for the probable cause conference that we had scheduled in June. Her phone was stolen, she was unable to appear on Zoom, but I did not know that day. She did call me the next day, and then when she found out about the warrant, she turned herself in, unbeknownst to me. I was not able to appear for her arraignment, but she was given the $5,000 bond, and she's been live for 16 days. So she's trying to find a way to bond out, but she can't get her father the money. She does have the 10%, but she's unable to get her father the money. So I would ask that the bond be reconsidered as a PR bond, maybe for a higher PR bond, just so she's unable.
What does a higher PR bond do?
Like a 10,000 PR bond.
But what does that do? It lets her out, right? Without having to pay anything?
Well, she doesn't show up again.
It does absolutely nothing. It's semantics. And this is not her first failure to appear. So it's at least her second failure to appear. She failed to appear on August 30th, 2024. The concern that I have on this is she was supposed to appear, and if you lost your phone, that does not mean that the court is closed. She had the responsibility to get to court, and she could have appeared in person at court, because that's where I was. I was here. And when she failed to appear on June 26th, she didn't come here June 27th to say, hey, I missed court yesterday. Tried to get here, couldn't, but I'm here now. Nonetheless, so I don't believe the bond is unreasonable because she's failed to appear on more than one occasion. So she will not get a PR bond. I can lower the bond and I'll lower it to 1,000, 10%. She needs to appear for all of her court dates.
Absolutely, Your Honor. And I wasn't aware of the first failure to appear. I wasn't on the case at that time.
You were not.
Oh, I'm sorry about that, but I thought this was the first one, but I did want to address it, and thank you for
No problem.
that as well.
Thank you. Okay, all of the bond conditions will continue. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing else. Thanks, Your Honor.
Thank you. You're all set.
Thank you.
Maybe Mr. Richmond? Oh, I think your client is here, Ms. Donnelly. Can I have Richmond file back because he's here now?
Which one, Your Honor?
Perhaps I just need to get a date.
Richmond?
Yes, please. I don't know. I saw that the other one. Oh, yes, what is the charge? The felony one, yes, that we issued. Okay, he's supposed to show himself in. Thank you. On the record, in the matter of the state of Michigan versus Lance Richmond 25-02015, council appearance.
Haley Fortuna Gill on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Lance Richmond, who is appearing separately by video.
Okay, Mr. Richmond.
Good morning, Your Honor.
Did you get, good morning, did you get tied up in cyberspace? Why are you late?
I did actually. I was having trouble linking up with my Wi-Fi and everything, so I'm not the
Oh,
most tech savvy individual. I apologize.
oh, okay. You have a probable cause conference today for controlled substance possession and then police officer fleeing and looting. Preliminary examination is scheduled for July 24th at 10:30. And then it's my understanding that you are aware that you have a warrant, a felony warrant. Is that correct?
Yes, that was brought to my attention yesterday by the public defender. Yes, I retained
So
counsel
why are
on
you
that,
not here in
and
person? Why are you not here in person then?
I had this set with my attorney James White this morning, and apparently he's not in the office. It was supposed to. I thought it was my understanding it was going to be taken care of by him, but there's a lot of confusion down there this morning. So
Down where?
they
At
at
Jamie
Mr.
White's
White's.
office?
Yeah, he's not
Oh,
in today apparently,
okay. So he
and
represents you on the other,
I had gotten
Hold on, Mr. Richmond.
you're represented by James White on the other file?
I am, Your Honor.
Okay, and so your understanding or is that you're coordinating when you're gonna turn yourself in on that warrant?
I am, Your Honor.
Okay, because he can't take care of it for you. He can only come with you to turn yourself in. And it's a felony, so you have to appear in person to be arraigned on it, okay?
Okay. Yeah, I've been unable to speak with him this morning. I'm just dealing with his office there.
Okay, you must appear in person next week for your exam, July 24th at 10:30, okay?
The 24th, you said?
That's your exam on this file, correct?
Okay.
Do you have any questions at this time?
I don't, Your Honor.
Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing for defense.
Thank you, you're all set, sir.
Thank you.
You're welcome. I saw Miss Shawn, but she seemed like she was trying to work some things out. And so that's Mr. Etheridge peeked in and he was gone again. I don't know what's going on with Mr. Etheridge. don't know what Mr. Eckridge is. Has anybody seen him?
Something in. Where is it? That's all I see him under.
Not much over than that. Still love time. Yeah, I got it. Of course. Just, no.
Oh, okay.
It's one of those where I had done so much on it already. Yeah, so I was like, I'll either just like. Yeah.
So.
Shrouds. Appreciate your. Oh, no problem. It was me.
You don't have a snack room up here?
A snack room? There is a vending machine on the first floor.
That should be easy.
But that would be great. Just a lounge.
Yeah, you said.
Need a cup of coffee.
Looks like there's.
I agree with you.
10. So, yeah.
No, just all I'm saying is,
Yes, all right.
So. As far as like the order of things.
Everybody getting up on what's going on.
Yeah, and, yeah. But
They got up quick.
How's it going?
We made it, right?
Yeah, we did. We just know we have to make it to the end Friday.
Yes. We'll make it one way or another.
I'm hungry. Yeah, baby. What you do?
Okay. I think, I'm gonna have him go get, yeah.
Carlos,
Okay, but we don't have Mr. Edwards, so. Charles, can you go get, love?
Oh, yeah, sure.
Let's turn it off, but usually don't get what I ask. Yeah, I charged this fee.
Okay.
I was on call when it happened.
Okay.
Search warrant, so I
Makes
just did it, yeah. Not did it, but. States on reading. See what I think I did ask for. I did ask for 250. So I was gonna ask for 150. Kind of moot point. Yeah. Yeah.
Oh.
Oh, and, Mr. Jackson. Oh, I know, yeah, for sure. Sworn he got it.
Oh.
Nothing on its face. Indicates that. I mean. You don't even have the case we were waiting for. And you get another one. And I don't know if he had a warrant.
Look like. First of all, what are you doing? No, that's the next.
Looks like. Oh.
Yeah, I don't care what. I just know that he was allegedly where he was.
And I think there's only two things there. And one of them is mostly-
Yeah, like certain song, yeah.
Action description. Right. So
Oh. A what? Yeah.
Like, oh.
I'm sorry.
Yes,
I know. I'm aware. Yes, sorry.
Yeah, like a presentation.
That's so good.
Yeah, and then. Looking at the teeth for me, I'm like, I don't know. You're the one who should know. Yeah.
Hi, how are you? Good, how are you?
Good.
It's just,
Yeah.
I mean, I'm not sure.
Uh-huh. Yeah.
Always something.
Yeah.
A couple of times here and there. There's all the things going on. Oh, I'm making that up. He was in Florida. Oh, or was he here?
Was that before I was in the
Yeah. He was the court officer.
Oh. We are waiting for
I
his
just didn't
attorney.
Yeah.
In Florida. So I don't, who's over there? Because Megan is. Is it Joe? Okay. Tell him.
Where do you want to jump?
You can sit right at the table. For his own sake. There you go. There. There.
Ross is like pulling up.
I do not think she does. Or she does, she doesn't.
She's not here.
Oh, she's not here. There
Oh,
you go.
well, there we go. I'm like, aren't you in court?
I'll be good with that.
All rise.
Almost after just here. You can be seated. On the record in the matter of the state of Michigan versus Tariq Love, 25-01266, appearance, please.
Good morning, Your Honor. Elena Cisneros for behalf of the people.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Love. He is present with me at council table.
I have Mr. Love scheduled today for probable cause conference, and my understanding is that he is going to waive his exam.
I believe it's scheduled for a preliminary exam, but ultimately, Your Honor is
Okay.
correct.
Wait, okay, you're correct. It is scheduled for preliminary examination, but there will not be an exam today. Is that correct?
That is correct, Your Honor.
Yes, Your Honor. My understanding is both sides will be waiving their right to their respective rights to the hearing.
Okay, thank you. Was there an offer at all?
There's not an offer as of right now. However, my office is keeping communication open for purposes of negotiations. My office did, for the record, receive a mitigation letter that prosecutor like Dwayne is reviewing. So the people do unconditionally waive their right and request fine over on most of the charges, but we'll be making a motion for dismissal on 2 of them.
Okay, well, we are waiting on which count?
The people will be moving to dismiss counts 2 and 6.
And I'm assuming there's no objection to that, correct?
That is correct, Your Honor.
Okay. Thank you. And so, Mr. Love, do you understand that you have the right to have a preliminary examination here in the district court on these charges? You understand the purpose of the exam is to establish, or to have the prosecution establish that they have sufficient probable cause that each felony that you're being charged with was in fact committed, and then probable cause sufficient to charge you as the individual who committed them. Do you understand that? And you wish to unconditionally waive your exam?
Yes.
Anyone promising you anything to get you to waive your exam? Anybody threatening you to get you to waive your exam? You're waiving it freely and voluntarily. The bind over date is July 30th. That's the date the circuit court will receive this file from the district court. You do not have a court appearance on that date, okay? Your next court date will be a pretrial. Your attorney will be made aware of that. Do you have any questions at this time? Bond this matter was set at 250,000 cash shorty. That will continue. Any additional matters for the record?
Yeah, may I address bond, Your Honor?
You may.
Thank you, Your Honor. As the court stated, it's currently set at $250,000. Certainly the seriousness of these charges is not lost on me. What I can tell the court, Your Honor, is that Mr. Love's prior criminal history is almost non-existent as far as I can tell. I know an iChat did not reveal any prior convictions that I can see. Our internal records suggest that he may have a couple nonviolent traffic misdemeanors from a few years ago. but I believe that would be the extent of it. He has a father, he has 2 children. The mother's children is in the courtroom today. They would all be residing here locally. And the reason why I bring that up is because I think it goes towards the flight risk assessment. I think that's going to be sufficient to keep him grounded in the community, not the jurisdiction of the court. He would be working on release. At least one of the life offense counts with Mr. Love have been dismissed at this point. The parties are both actively engaging in negotiations to resolve this matter. The charge involving, I think, the one remaining victim in this case, Mr. Young, I think this is something both parties would agree on, that prior to this offense date, Mr. Young and Mr. Love were strangers to each other. So I don't think there's going to be any issues with him abiding by the no contact order. Certainly while he has been incarcerated, there have not been any allegations that he's been attempting to do anything to circumvent the orders of the court or to tamper with witnesses in any ways. So, Your Honor, I would ask the court to consider all of that and respectfully ask the court to grant Mr. Love some relief of his bond, either in the form or in the amount.
Mr. Prosecution, go to respond.
I think, Your Honor, yes. As the court is aware, Mr. Love was arraigned and the bond was set in the amount of 250,000 cash or surety. I think that was appropriate. That was requested from my office. I understand that 2 out of the 7 charges were dismissed on motion of the people today. However, I would ask the court to either deny that motion or to set bond at a lower amount, but still a high amount, somewhere in the realm of 100,000 cash or surety or 150,000 cash or surety. This was shooting that was almost entirely caught on surveillance video from the gas station parking lot for that. Like I said, clear video with other individuals that were witnesses to this incident. Given that, Your Honor, I would ask the court to either deny the motion or to set it still at a high cash surety bond.
Okay, so even, well, first, before the bind over, we were facing a 7 felony count here. The most serious being count 1 and now count 2, which is dismissed, and count 3. We have assault with intent to murder. And the allegations, at least as they are pled in the affidavit of probable cause, are concerning public place, a gas station, allegedly, an interaction where your client allegedly introduced a firearm and attempted to rob someone at gunpoint, and when they fled, allegedly your client discharged that weapon. If true, this demonstrates a reckless disregard for life. It's just, we're just gonna start shooting at a gas station like we're in the Wild Wild West somewhere into people's cars. And I think if that's true, then the bond is more than appropriate. And it's unfortunate that Mr. Love is a father that he's now separated from his children. But if these allegations are actually true, then he should be separated from his children. Because we don't need people who can't process the value of human life out in the public because they can't control their actions over money. The attempt to take someone's life over money is definitely nothing in comparison to the $250,000 cash surety bond. I don't have his prior criminal history. I take your word for it that he doesn't have any prior convictions. But if you didn't have any prior serious convictions and you jump into these types of felonies, this is slippery slope. It's dangerous. You're facing life in prison. Hopefully you understand the severity of that. I'll lower the bond, but it's up for him to post a bond, because I think that there is a threat to the public safety. A bond will be set in the amount of 85,000 surety with GPS tether and victim notification if possible. The bond conditions will continue. Any additional matters for the record?
Nothing from the people, Your Honor. Thank you.
I have nothing additional back, Mr. Rowe. Thank you.
You're all set. On the record, in the matter of the state of Michigan versus Jeffrey Smith, 25-01214, council appearance.
Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Attorney Derek.
Excuse me? I apologize for that. You can continue.
Good morning, Your Honor. Attorney Derek, also the public defender on behalf of Mr. Smith, who is in the courtroom standing to my right.
Okay, I actually forgot file 25-01341. Today was the date scheduled for a sentencing. And I don't have PSIs on either because your client failed to follow my order, which was to report to pretrial services, which is our probation department, within 48 hours of his release from jail, so that a PSI can be done. So here we are, 2 months later, at a sentencing date with no PSI, so he'll be remanded into Ingham County Jail custody. And this sentencing will be reset.
Not entertaining any explanation, or the court is set on this remaining.
I don't see how there is an explanation because it's been since May and he's not ever reported to probation. So I'll listen to what you think it is a reasonable explanation.
Your Honor, he advised me, and as the court considered, since being released, he had been in the hospital approximately 4 times regarding medications, breathing issues, and seizures. He did have phone issues. He did advise me he did report to community mental health as the court ordered, and had been checking in with them bi-weekly and meeting with a therapist there to he remains homeless. He has a new phone number. He has talked to our social worker this morning, who will try to assist him in any way possible. But those are some of the explanations of why he missed the court's, did not follow the court's order, didn't report within the time frame. Why he didn't call or report after that, I am not sure.
Maybe he can tell me why he didn't go to probation.
In the hospital, I was homeless, I have no transportation, I'm indigent,
You've been indigent this entire time. This is not new.
I have no transportation.
You got here today.
Yes, I walked.
You could have walked to see probation then. You have 2 charges or files pending, assault of one of them, the other in impaired driving. Why is it that you think that these are excuses where you don't have to follow court order? And then I'm supposed to put you on probation and think you're gonna follow my order now? All the same things that you're using as excuses are all the same things that would make you a terrible candidate for probation, which means you need to do jail time. That was May 30th, I told you to report to probation. You know what today's date is? Of July. You have not been in custody every day since then. No, but you have not made your way. And what hospital were you at?
Sparrow.
Which is down the street. But you want me to believe that you didn't have transportation. When you were released from custody from care, 2 blocks or 3 blocks up, you mean to tell me you couldn't come up here and meet with probation?
At that time when I got out, the office was closed.
4 times.
I don't remember that time.
You know why you didn't meet with our probation department?
I met with them once. And
Not on these files, because they left a note that it says here that they attempted to meet with you. Defendant was ordered to make contact and schedule a pre-sentence interview with probation within 48 hours of release. Defendant did not make contact. That's on both of your files.
I The only time I'm aware of that he made contact is after he pled, I walked him down there and they gave him those instructions, or the court gave him those instructions.
He must have been in custody if they're saying that he was supposed to report within 48 hours of his release. I don't know why. Because if he was in person to take a plea, he would have been escorted downstairs immediately. We don't tell you to report unless you're not here.
Were you in custody at that time? When you fled? Well, you got a PR bond.
I was
that
in
day.
custody, yeah, when I got a PR.
Then I'm not sure what he's
Yeah,
talking
he
about.
was in custody. It says PR bond was on the same date that I released him.
So I'm not sure what he's talking about, Your Honor.
I don't either. Had to put him in custody because he showed up to court under the influence. He's remanded.
Sentencing dates to follow, Your Honor, or do
We can get you due date now.
September 12th at 9.
September 12th at 9. He's remanded until the time that he meets with probation, and then his PR bond is reinstated.
Thank you, Your Honor.
You're all set.
So to work for any services you can do. I'll talk to you.
See here, do you have someone else? Where is that? Ms. Schroeder.
Schroeder, I think is on more.
Huh?
So she just said, I promise I'm working on getting over it. I'm so sorry for the.
She's on the record?
Let's see, which court?
It has to. Yes, we can bring up grown-ups.
Yes, sir.
And then is Melissa Morrissey here?
Not seeing her, Your Honor. I will check the whole one on that, if that's all right. She's not in the hallway.
Sure, which one? On the record in the matters of the state of Michigan versus Carl Knox. I have 25-01-335 and 25-1307. Appearance, please.
Haley Fortuna Gill on behalf of the people. Thank your honor, Assistant Public Defender Aaron Schroeder on behalf of Mr. Knox, who stands to my right.
Both of these matters were scheduled today for preliminary examination. And my understanding is that there's a request to adjourn.
That is correct, Your Honor. People have been in contact with the victim in this case, and she is in a treatment facility. I do understand that she was in a treatment facility the last time this was set for preliminary exam. I do know that she is set to get out next week. We do have our officer here, so in the alternative, we could begin the exam and request a continuance. However, the people would prefer an adjournment if possible.
Your Honor, this is the first I've heard that there's a potential outdate for this witness from her treatment. We were here the last time and it was the same reason. We had to do an adjournment. Mr. Knox is currently being held in custody on these matters. I do acknowledge that there might be a probation violation that also is holding him on a misdemeanor matter, but I think that the two files here, the two felonies are absolutely the main reason he's remained in custody since the beginning of May at this point. And we were ready to go the last time, and I made the same request of the court to deny the motion. And here we are again, and I'd ask the court at this time to deny the motion because it is my understanding, even though they do have an officer here, that officer can't make identification. So if we come back at a later date and she doesn't come again, we still have the same problem. So I'd ask for dismissal of both files. Thank you.
I'm assuming you have some communication with your victim. Is that how you know where she is?
That is correct, Your Honor. Our advocates have had communication with the victim. I do also want to note that these cases are something that our office would reissue when the victim gets out of treatment if it was dismissed today.
Okay. My notes for May 22nd that the victim was in the hospital and I reset it for this date. We didn't have at the time, an outdate. So I agreed to set it until she got out of the hospital. Sounds like she's getting out of the hospital next week. Had we known the date then, this would just be reset until after then versus coming here today. I don't enjoy starting an exam that we can't complete, but if you want to proceed with a witness today, that's fine. I don't know if that throws off how the evidence gets laid out. They've demonstrated that they've had contact ongoing with the victim, meaning they know where the victim is and if the victim, I guess, is expected to participate in this. Your client is not being held without a bond. There's a bond in both of these matters. One of them quite low, 7,510%. The other one, 5,000 cash surety. And these are being charged, I believe, as a habitual offender court offense notice. And the people would only reissue this if the court even entertained the motion. And then I have a bond violation, at least on one of these files. You said there was a probation violation as well?
I show there is a violation for a matter, misdemeanor matter that is with this court. I don't know if it's related to this or not, but Mr. Raleigh from our office is representing it set for a probation violation hearing on the 21st, so next week at 1:30.
Probation violation is essentially that he picked up the new case. And it looks like, I'm trying to figure out this violation. But probably new case. So the motion to dismiss is denied. This matter will be reset. Since she's expected to get out of treatment next week.
That's correct, Your Honor. The date I was given was the 24th of July.
August 8th at 9. August 8th at 9. And we might as well go ahead and reset that probation violation. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing on behalf of Shawn.
You're all set. I think that's all I have for state cases today.
Thank you, Your Honor.
No.